I'm very sorry about the manner. This wasn't by design. We did have Professor Kate Regan was supposed to be on this panel. Unfortunately, she has COVID and sends her apologies. So I'm afraid you have ended up with 4 men. But as I said, we didn't plan this. So we'll start with Professor Jeff King.
Thank you very much, Taran. So the social rights commitments in the Brown Commission report are a very, very important feature of the overall package. And in the next 10 to 15 minutes, I'd like to discuss the context for those proposals, what the proposals are, to make some brief international comparisons with other constitutional provisions doing this, and then come around to 4 key issues about how the operation of these proposals would be realized. On the whole, I support the proposals. I consider them meaningful, but as the report itself calls for, they need greater development, and I think that development will encounter a lot of resistance. I think at the end of the day, I think that the report and the approach will need to recognize that the social rights provisions will be more lightly enforced by the courts, even than the report lets on, and that the political practice of the political protection of these rights that the report alludes to will become quite important. So let me begin with the context for the proposals. They're contained in Chapter 6 of the report, which is entitled Renewing the Purpose of the United Kingdom. They don't have their own chapter. Why so? Well, it's the discussion in Chapter 6 that the function of the Union of the United Kingdom is put forward, and it articulates a vision of shared social citizenship, a social compact, and it wants to give this constitutional status. Now, Chapter 6 addresses the function of the center of the Union and the social citizenship that would exist in all 4 nations. And one aspect of that is, to quote, the UK should seek to provide economic opportunity and security for the whole of the country. Now, there's a lot in the report about significantly increasing devolution and regionalization. And at the same time, there's a significant amount of study of federalism in the welfare state. It's a known feature of federalism in the welfare state that social policy is in a tricky situation. There are many more political veto points in policymaking. It's a much studied issue. The German political scientist Fritz Sharp coined the expression the joint decision trap of having to go through 2 or more levels of government. Now, luckily for the proposals in this report, that same body of literature says that although expanding a welfare state can be very difficult in federal polities, it's also harder to contract a welfare state for the same reasons that you need to get a lot of political agreement. So the way that the issue is addressed in these proposals suggests that we might be a little less worried about social policy in the federation or the devolved government than we might otherwise be. So the Commission's proposals as a whole try to find a common core of social citizenship and make sure that it doesn't become a sort of free-for-all postcode lottery. Devolution is one, regional development is another. At a constitutional level, there's a proposal for an explicit constitutional requirement to rebalance the economy, and it takes inspiration from German and Canadian approaches to this in the Constitution. And this is where social rights comes into the package. It's meant to fill out a picture of what the Union is supposed to do and to secure to ensure that there is a common social framework that is protected by the UK Parliament. Now, what are the proposals? So, slides up for a moment. Very technical difficulties. Slides aren't moving forward. I assure you there are other slides. The wording of the rights proposals are contained in the report. I had the page number written down at one point. Right, it's page 72, exactly. So there is protection of, thank you, I've got mine here, of health, of education, of rights against being destitute and poverty, and to protect housing within the framework of the relevant law relating to housing and homelessness. So we can, I hope, see these on screen at some point in the future. The point here is that the report considers whether these rights should be protected either in an aspirational form or in a concrete form. The aspirational form would see them protected as policy objectives, but the report clearly prefers a concrete form. And the reason it does so is it wants to put these across as guarantees. Now, I wanted to take a look at international comparisons of how other countries in Europe in particular have constitutionalized social rights protections. Since I can't have the slides work at the moment, I'm going to move that later on into my discussion in the hopes that Liam reappears, can help me, and move on instead to a discussion of 4 difficult institutional issues that are found in the proposals to protect social rights here. The first is the idea of entrenchment. The report puts very serious stock into the idea of the rights being guarantees, in the claim, for instance, that embedding them in the Constitution is the most important thing, as it will entrench. Thank you. Let me make sure I can do that on my own. Right. Okay. Yes, indeed. So they're the rights. I'm going to continue explaining, dealing with the 4 issues that I think need to be dealt with. The question is really, what does entrenching these rights mean in this report? The word entrench appears a lot in the report, and it's defined in the chapter on the proposal to create a new second chamber, the Assembly of Nations and Regions. In general, the concept of entrenchment in the report is that the second chamber could block legislation where it relates to a defined set of constitutional statutes. So there'll be a schedule with a list of constitutional statutes. And the idea is that the House of Lords, or the Assembly of Nations and Regions, which is generally not allowed even to delay legislation significantly under these proposals, would be allowed to block legislation that relates to those issues. And if a question about whether it relates comes up, it will be referred to the courts. Fine. Now, where does the protection of social rights fit in here? Will it be on the list of protected constitutional statutes? The report is ambiguous here. It says, quote, and this is on page 142, the individual rights we discuss above will be sustained by a balance of direct enforceability with constitutional protection. Now, it looks to me that that means that the courts will be partly involved in enforcing the claims, and also that the new second chamber could possibly block legislation if it relates to the social rights provisions. Now, wanting to be as idealist as I can, I nevertheless think that that second function of the Lords blocking such legislation is unlikely to materialize, because the report itself emphasizes that this new chamber, quote, should have no responsibility for decisions about public spending or taxation, including national insurance. And that is a very old principle in the way that Parliament is organized. It will be difficult to unseat it. What's the upshot of that? It means, I believe, that the role of the courts comes into greater focus as the possible guarantee. And that puts the proposals on something of a dilemma. Either the courts play a very important role, which the report says it doesn't want to see happen, or you need to have some combination of a more mild judicial role and a more active political process to try to vindicate these rights. And I think that second approach is possible, and I want to say something about it when we come around to it. So that's the first issue, is entrenchment and what it means. The second is the issue of devolution. Most of these social rights provisions that are on screen now, I think all of them, concern devolved matters. And that means creating guarantees in legislation would require obtaining legislative consent or legislating in defiance of the Sewell Convention. Now that wouldn't look very good in the overall package of proposals here. So the report proceeds on the basis that there's likely to be consensus on these rights between the 4 nations, and also that these rights floors this minimum level of protection doesn't prevent the devolved legislatures from going beyond the guarantees. But it adds, a Labour government will rightly seek the consent of the devolved legislatures before doing this. I can't see it proceeding without the consent of the devolved legislatures. So the political conditions for obtaining that consent will likely mean some important political concessions. And in particular, what seems to me politically unpalatable, unthinkable, is that Westminster would create a regime that will impose further mandates on devolved governments through the agency of the courts or whatever that are not funded properly by central government. So the financing arrangements probably in the Barnett formula will need to be examined. At the very least, there should be a proposal that the social rights provisions will come with some procedural mechanism for funding the kinds of mandates that any serious implementation of these rights provisions could produce. But that can be turned into an advantage. Then the government would come to the devolved, the UK government would come to the devolved governments and legislatures, not just with a proposal that it enact law that would impose constraints, but that it would come with a package of resources where they were resource intensive. So I don't see that as an impossible hurdle. The third issue is how would the Bill of Social Rights function in the courts? You can see them on screen here. This is a matter for consultation, first and foremost, but I want to suggest a plausible way in which this could take place. So I assume this Bill of Rights would be enacted in statutory form. It will be its own statute. And I think the complete set of proposals needs to make clear two things to begin with. First, that resource rationing is compatible with the idea of constitutional protection of social rights. And secondly, a general posture amongst judges of judicial restraint is also not incompatible with the protection of social rights. I've argued both of those things in my own work on social rights as an advocate of them. I think there's no doubt that UK judges will be all too happy to run with those starting points. Now, it's a well-studied phenomenon where courts of law have taken social rights provisions and given them wide interpretations that have imposed unfunded mandates on social services. The distortion of resource allocation has been studied where this problem has taken place in serious measure. The proposals in this report are alive to that. So that's one of the reasons why the report, as far as I can tell, consistently refers back to giving effect to the commitments that it considers the UK already to be in principle committed to. It is committing to existing political commitments such as free treatment, medical treatment on the NHS. You can see it's debatable whether the UK is genuinely committed to those principles, but that is part of the effort here. Now, that has two effects, I think. First, it makes the commitment one that's going to resonate more politically with members of the public if you keep it at a high level of discussion. And second, I think it means that judicial enforcement of the guarantees will more likely lead to incremental changes through litigation and status quo safeguarding rather than the mandating of unfunded changes to the delivery of social services. So it won't be a Beveridge moment, but I think that is very intentional here. So what model of legal effect could this bill actually have? I don't think it's going to be the model of Section 6 of the Human Rights Act, where they will be what they would say in France or Germany, subjectively enforceable legal claims, freestanding legal entitlements that you would come to court and challenge a government omission or an action saying that you would like to see your right to housing fulfilled. I think it's more likely that the rights provisions will be used to interpret the dense thicket of statutory and regulatory laws that apply in all of these areas here. And it is a very dense thicket indeed. I counted up the number of social security statutes and statutory instruments when I wrote my book on judging social rights 10 years ago. And there were at that time 56 statutes relating to social security and over 2,000 SIs. So it's densely populated. The same thing exists with housing. All of these areas have their own law reports typically and also their own treatises. The way I think that the Bill of Social Rights could plausibly be inserted into this, and meaningfully so, is to introduce an interpretive obligation to have regard to the social rights that would be recognized in the Act. What would that look like? I'm going to skip over some other constitutional provisions. It's a funny font here. But this is the kind of thing, for instance, I think could be plausible. This should be a comma here. Yeah, these are commas. Now, so the idea here is when interpreting an existing statute or considering an application for judicial review or enforcing a particular regulation, the courts adjudicating the dispute could have regard to the social rights that are recognized in the statute. And in cases where there is legal ambiguity or doubt, they should give the interpretation of the law that will give greater protection to social rights. It's not a revolutionary change in the way the law would operate, but it would have some effect, I think. It would impose a higher standard of judicial review, would probably introduce a measure of anxious scrutiny in the way that judges interpret and enforce the law relating to all of these areas of social rights. And I think it could be meaningful. Now, that is not the only way in which the social rights would be protected. It would be a disappointment if it were. I could explain what I think the ideal approach to protecting social rights as human rights would be. It would be to appoint a commission, such as a commission on the social minimum, staffed with independent experts. They would study what a social minimum would be using the kinds of techniques that are applied in poverty research and in social studies generally to determine what the social minimum is in various regions of the UK, and then enact a law mandating that social security benefits shall be available to persons that will secure that social minimum to them. That's how it can be done in a legally secure way. It will not be done that way, though, because that commission would end up having the power to require enormous amounts of expenditure. It would probably, to lift the boat to cover the social minimum, I think we'd be looking at an adjustment of over 2% probably of the national budget based on the kinds of figures that I've seen. And relinquishing that political control would certainly be a step too far, I think, for any government. The proposals in the report suggest, rather than something like that, you could have a body like the Equality and Human Rights Commission that can monitor and report on the observance of these social rights principles throughout the UK and report to Parliament about it. Now, I think that is a promising avenue of change. We've had other precedents for this. They're not always effective, like the Climate Change Committee, for instance, because they're not always listened to effectively. But it is an approach that will put reports into the public domain, require parliamentary debate. It was an approach that will probably allow the commission that would carry out these functions. I don't think the EHRC could do it because it would have to be something the four nations would agree to, probably a bespoke body. But an institution like that could carry out that function. And I think between that new political procedure for having discussions about the social rights principles recognized in that act and a relatively mild interpretive obligation such as this mean that the recognition of those social rights principles could be a meaningful change and could go some distance towards fulfilling the function for the social rights provisions that the Brown report envisages. I'll stop there. Thank you, Todd.
Thank you very much, Jeff. That's fascinating. Stephen Hoffman, QC.
Thank you very much, and good afternoon, everybody. Very much looking forward to this. I still feel that. So when Sir Geoffrey Joel, whom I've always regarded as my mentor in these matters, walked in the room, I realised that, or like my first supervision in my first year at Cambridge. I very much applaud the summary that Jeff has given, and I'm not going to be able to do more than cover similar ground and perhaps expand on one or two of the points that he's already made. I'm going to cover three things. I'm going to talk a little bit about the way in which these rights might be defined. I'm going to talk about entrenchment, about the protection of the rights, and I'm going to say something about the role of the courts. But I'm certainly not going to be able to cover things as comprehensively as Jeff has already so admirably done. So just talking about the way in which the rights are defined. As Jeff has already pointed out, the Commission has already adopted quite a bold approach in relation to that, and that is extremely commendable. In thinking about this and trying to decide whether we should simply accept what the Commission has said, coincidentally, I came across a book which I had on my shelves and which was gathering quite a lot of dust. It's a book that was published, I think, in 1999, and it was called Crossland and New Labour. I'm sorry that Patrick Diamond isn't here anymore because, of course, he wrote an absolutely brilliant biography of Tony Crossland, which I hope everybody has read. Crossland and New Labour contains a fascinating chapter written by a chap called Peter Kellner, who some of you probably know. And this chapter refers to the phrase equality of access. So it's this concept of equality of access that Peter, and he says that the way that we should embody these rights is to say that everyone should have equality of access to various things. He includes some political rights as well, the ballot box, information that enables people to hold to account those who wield power, representation, safe and peaceful neighborhoods. And then he goes on to say equality of access to reasonable, affordable housing, healthy, affordable food, prompt and appropriate medical treatment, education, and as it happens, he adds, the means to generate an income without detriment to dignity or health that is sufficient to sustain a reasonable livelihood. Now, the detail of this would obviously need to be thought through, but personally, I was rather impressed by that formulation, equality of access, which in relation to social rights, I think is perhaps even more appropriate than the very valuable formula that is contained within the report on the screen. So I would like to see a little bit of consideration of the Kellner approach. What I think we ought to recognize is that the objection to this, which is sometimes put forward, which is that these things impose on the state not merely the kind of negative obligations that you generally see in the European Convention and in relation to constitutional rights. The objection sometimes is that these kinds of rights impose positive obligations on the state, and that's inappropriate. And there's a very, very good discussion about this in a book called Comparative Human Rights Law by Professor Sandra Fredman of Oxford, who makes it clear, and I won't take up too much time on the detail of this, but as she points out, there are some paradigmatic civil rights, such as the right not to be tortured, that carry with them some element of positive duty on behalf of the state. And as well as refraining, she says, from torturing individuals directly, the state must protect individuals against interference by other non-state actors. And at the same time, she makes the point that socio-economic rights of the kind that we're talking about do not necessarily impose positive duties. So the right to freedom of association, to strike, and the right to collective bargaining are socio-economic rights, but they don't necessarily impose positive duties. So the idea that you can object to these proposals on the basis that they impose positive duties on the state, I think is now exploded and is to be seen as outdated. And so I agree generally with what Jeff has said about this, and I think that definitely be seeking to do this. That's what we would hope that the next but one Labour government should be willing to introduce, and that should be our starting point. Now, let me say a word on the question of entrenchment, and I should make it clear that the Society of Labour Lawyers, which I chaired a few years ago, has been doing quite a lot of work on this. Two of my colleagues who are here, George Alberston, have committed their very considerable brain power to an elucidation of this concept. And again, I'm going to be sort of borrowing from the sorts of things that they've been saying. Speaking personally, and I suspect for them as well, I don't think that we should necessarily rule out the idea that these rights and maybe others can, even under our system, be entrenched. Sometimes said that because we don't have a separate constitutional document which somehow stands above ordinary legislation, that entrenchment isn't really possible. I don't think that we take that view. I think that we believe that constitutional legislation can be entrenched and probably should be entrenched in due course, and that could be achieved in a number of different ways. And Jeff has touched on this. One way, and as Jeff said, it's a method that the Brown Commission seemed to have espoused is to give the second chamber a veto. But as you said, Jeff, that might be thought to be a little bit inconsistent with the way in which the Brown Commission, at any rate, views the role of the second chamber. All of that is part of a wider discussion, which there isn't time to go into now. But there is an alternative, which we've certainly been discussing, which is that you might, in the case of constitutional legislation, require what is sometimes called a supermajority in the House of Commons before any valid repeal could take place. So you might say, in relation to protect, and after all this session discussing methods of protection of social rights, you might say that you'd need a majority in the Commons before there could be valid repeal of that legislation. Yes, it is true that the extent to which that requirement would be enforced by the courts might be open to some doubt. We don't know whether the courts would. So my own feeling is that they might well, because after all, what would be the point of passing that sort of legislation unless it was meaningful? Legislation as to the manner and form in which particular types of legislation can be repealed would be meaningless if it wasn't effective. If Parliament the following week could pass another statute sweeping away the entrenchment provision. So I think there would be a strong argument in favour of the enforceability of that sort of legislation. Acknowledge that it is yet uncertain. What we can say, I think, is that that kind of provision, that kind of manner and form requirement would have political impact. If Parliament were to pass legislation in that form, of course, there would have to be what's sometimes called double entrenchment. In other words, the entrenching provision itself have to be stated to be entrenched. Then I think that make it much more difficult for any subsequent government or any subsequent Parliament to repeal the provisions which were entrenched in that way. So I think that if we're talking about protection, the possibility of entrenchment should be considered. I noticed that Jeff didn't go quite that far in what he said, and indeed he suggested subtle proposal, namely to have an interpretive obligation to have regard to the provision. Say a more subtle and maybe politically more acceptable approach. It'd be interesting to hear people's views about this. A slight concern which I have, if one adopts a more limited approach of that kind, is that it doesn't and really achieve entrenchment of the legislation. It might well have a positive impact on individual governmental decisions, but that interpretive obligation by itself would not, in fact, entrench the enactment in which the rights were created. It would do nothing, in other words, to restrain a later government from repealing the. I think probably it would not be right to describe that as a method of entrenchment, and that's why I think that we ought proposing a method of entrenchment which would that a later parliament couldn't. So that's what I wanted to say about the question of entrenchment. And then finally, let me say something about the potential role of the courts. I think that there are some jurisdictions, I think possibly India, where the courts are excluded from dealing with kind, and where it is in effect the position that these are matters left for politicians to decide on, precisely because of the resources. I would be very disappointed if that were to be the case. I don't see any reason myself why the courts shouldn't have a role in this. And in the book by Professor Fredman that I mentioned earlier, she discusses what I thought was a very interesting South African case. Area, but in a South African case in which the then Justice O'Regan was presiding, the discussion was about the right to water, which was one of the rights, which is one of the rights protected in South Africa. And Justice O'Regan in that case said that the right obliges the state to take reasonable legislative and other measures progressively to achieve the right of access to sufficient water within available resources. There you have the courts formulating an interpretative principle in relation to the application of the right in particular circumstances. I think that shows how the courts could play a part. And if it is then said, well, do we really want the courts to be undertaking what might almost be described as a quasi-legislative role? In preparing this little presentation, I came across an extraordinary paper written in 1945 by the professor of law at Cambridge when I was there, Glanville Williams, and it's a paper called Language and the Law, in which Glanville deals explicitly with the role of judges in trying to decide on which side of the line a particular set of facts falls. And Glanville points out that judges are not normally intimidated from saying that the case is on one side or the other of the line, merely because they discover that the line is difficult to draw. He says, if marginal cases must occur, then it may be that the function of the judge in adjudicating upon them can be described as legislative. The distinction between the mechanical administration of fixed rules and free judicial discretion is thus a matter of degree, not the sharp distinction that it is sometimes assumed to be. This is not to say, says Glanville, that judges have an unlimited legislative power. A judge has a discretion. This is rights, I admit. The judge has a discretion to include a flying boat within a rule as to ships or vessels. He has no discretion to include a motor car within such a rule. I'm merely citing that in order to show that day in and day out, judges are making this kind of assessment, just as Justice O'Regan did in the water case, and that we should be prepared to trust the courts to make those assessments. There are very few cases in which you can make a decision which doesn't involve judicial assessment and evaluation. Anyways, this is precisely the sort of case in which the judge have an important part to play.
And finally, Colin Coffey.
After setting out our role in advising on a Bill of Rights for Northern Ireland, I then considered the need for improvements in the policy-making system to support any additional rights protections for socioeconomic rights in the UK. And finally, I'll make a short observation on the devolution settlement and its implications for rights protections. So the Northern Ireland Human Rights Commission is the national human rights institution for Northern Ireland. The UK is quite unique in having 3 national human rights institutions. And for anyone unaware, national human rights institutions are independent statutory bodies that are accredited by the UN as being independent of government. So our remit extends to both devolved and non-devolved matters in Northern Ireland. In contrast, the Scottish Human Rights Commission was established by the Scottish Parliament, and it has a remit over devolved matters in Scotland. And the Equality and Human Rights Commission has responsibility for rights in England and Wales, and I believe non-devolved matters in Scotland. The Brown Commission refers to the Equality and Human Rights Commission, suggesting it undertake a role relating to social rights throughout the UK, but does not acknowledge the role of my commission or indeed the Scottish Commission. And respectfully, I would suggest that requires reconsideration. My institution was established as a result of the Belfast Good Friday Agreement, and we're the sole body mandated to promote and protect human rights in Northern Ireland. We also have a mandate to work with the Irish Human Rights and Equality Commission with respect to rights on the island of Ireland, a role that has been enhanced as a result of the Windsor Framework. So I think it would be useful in the next iteration to consider our role in that of the Scottish Human Rights Commission. You may be aware that the Belfast Good Friday Agreement proposed that the Human Rights Commission have a role in advising on a Bill of Rights for Northern Ireland. It was made clear that our advice should relate to rights which are supplementary to the European Convention on Human Rights and which reflected the particular circumstances of Northern Ireland. Socioeconomic rights were not expressly referred to in our brief. However, there was a recognition within the agreement that discrimination in the enjoyment of socioeconomic rights was a contributory factor to the conflict. The development of a Bill of Rights effectively dominated the first 10 years of the Commission's operation. Whilst we had a number of polls which demonstrated high levels of public support, both for a Bill of Rights and for the inclusion of socioeconomic rights within the bill, there was a lack of political consensus on the content of a Bill of Rights. Broadly speaking, unionist elected representatives were opposed to a broad-ranging Bill of Rights containing economic and social rights, and nationalist elected representatives were generally in favour of a broader Bill of Rights. The opposition from unionist politicians to economic and social rights seemed to be a concern that they would provide a much greater role for the state, and concerns regarding both affordability and enforcement. Our advice proposed protections for the right to health, the right to adequate standard of living, the right to housing, and the right to education, the 4 rights referred to in the Brown Commission. Although the proposed provision relating to the right to education was more limited, as this right is already protected within the Human Rights Act, we recommended that a judicial remedy be available for all rights protected by the Bill of Rights, including socioeconomic rights. Upon presentation of our advice, the then Secretary of State for Northern Ireland, Sean Woodward, stated that the government's initial assessment is that over half of the rights proposed in the advice are equally as relevant to the people of England, Scotland and Wales as they are the people of Northern Ireland. And it was the government's view that the introduction of such rights in Northern Ireland alone would either be unworkable in practice or give rise to unjustified inequalities across the UK. effectively calling for full regulatory alignment throughout the UK. The Northern Ireland office further considered that economic and social rights were outside of the democratic mandate of the judiciary, emphasising that the democratically elected government must retain full responsibility for the prioritisation of expenditure, and therefore they were not appropriate in an enforceable Bill of Rights. It was also highlighted, in a line that I've heard many times since, that the UK's international obligations with respect to socioeconomic rights are met through a combination of entitlements in domestic legislation, policy schemes, and administrative action. Since this initial response, the UK government has continued to express its support for the concept of a Bill of Rights for Northern Ireland. However, it's highlighted that in the absence of agreement amongst the Northern Ireland parties, this cannot be progressed. The prospect of a Bill of Rights for Northern Ireland rose in 2020, with the Northern Ireland Assembly establishing a committee on a Bill of Rights. However, unfortunately, again, there was a lack of consensus. The same concerns emerged that the inclusion of socioeconomic rights could lead to judicial usurping over the legislature. Also, this concern that it could lead to disparity in the enjoyment of human rights throughout the UK received significant attention. One response pointed out that Wales and Scotland were moving forward with respect to rights protections, so it was not that much of a concern, which I'm sure provides a lot of comfort to anyone living in England. But I think it is interesting, the idea that a move to socioeconomic rights protections has to be on a UK-wide basis. Our advice on a Bill of Rights drew heavily on international instruments, including the International Covenant on Economic, Social and Cultural Rights, and the duty contained in the proposed articles for protecting health, standard of living and housing all included the following proviso, namely that public authorities must take all appropriate measures, including legislative measures, to the maximum of their available resources with a view to achieving progressively the full realisation of this right, similar to the formulation that Stephen gave in the case. In our advice, we set out a number of measures to support implementation, and regrettably these measures this element of our advice have not really received much attention. And part of the reason for that, I think, has been the focus on the justiciability of socioeconomic rights. Since we published our advice, theories around human rights implementation have developed significantly, and the Office of High Commissioner for Human Rights has developed its thinking around the National Human Rights Protection System, which acknowledges the full range of actors, in particular state actors who play a role in implementing human rights, with the National Human Rights Institution taking a central role. In the context of socioeconomic rights, implementation calls for significant and sophisticated coordination across government and effective participation with civil society. In designing appropriate measures, there's obviously a vast range of state actors involved in any measure relating to health, poverty or housing. The UK Parliament or devolved administration will undoubtedly be the key decision maker in agreeing measures. However, there is a need for more participatory initiatives that involve the intended beneficiaries of any measure in the design process. And I think it would be worthwhile looking at how we foster the participation of marginalised groups and their representative organisations and how they are funded in this discussion on socioeconomic rights. An assessment of whether measures are using the maximum available resources is slightly more straightforward in a devolved context. In our case, a block grant is provided to the Northern Ireland Assembly based on the Barnett formula. However, whilst much has been written on human rights-based budget analysis, there are relatively few examples of such analysis being applied in practice. In the Westminster context, where the government has the ability to borrow, budget analysis is much more complicated, and people may be familiar with the debate relating to the necessity of austerity measures included in the Welfare Reform Act 2012, given the ability of the UK government to borrow at relatively low rates of interest. When considering the maximum available resources, our minds tend to turn to thinking how could a court settle that argument, but I think we also need to consider how assessments of the maximum available resources can be conducted to assess allocations across government, demands based on the needs and rights of all. In assessing whether measures are progressively realising the relevant right, there is a need to consider what are the indicators of progress and whether the data collection system is sufficiently robust to inform an assessment of progress. In addition, there is a need to look beyond statistics and to capture the lived experiences of the intended beneficiaries. The Office of High Commissioner for Human Rights has recently developed a set of human rights-based indicators in the context of disability rights, and there are many examples we could draw on. The development of human rights-based indicators is, in my view, a key activity which must go hand in hand with the enactment of any measure relating to socioeconomic rights. In concluding this section, I consider that we need to see more sophisticated policy-making processes and impact measurements as going hand in hand with additional rights protections. In relation to devolution, as I've said, the UK government has consistently stated that economic and social rights need to be developed on a UK-wide basis, but I would question how welcome a UK-wide measure would be in this area for the devolved administrations. The policy areas of housing, schools, health and social security all fall to the devolved administrations. How willing would any devolved minister be to cede their discretion to new rights protection measures, which will presumably be contained in an Act of Parliament? The suggestion in the Brown Commission report to amend the legislative competence of the devolved legislature, there's a suggestion in the Brown Commission report that the legislative competence of the Northern Ireland Assembly and the Scottish Parliament and the Welsh Assembly would be amended. But I struggle to envisage what such amendments would look like. If a devolved administration was found to be in breach of a duty or right, would this then open up the potential for the Westminster government to step in? I imagine that a devolved government would be happy to receive additional funding, but less happy for Westminster government to step in and make decisions on the allocation of scarce resources or on the prioritisation of projects. People will be aware that the UK Parliament recently legislated relating to the provision of sex education in Northern Ireland, a decision which has been criticised by the Minister of Education for undermining the devolution settlement. And there's a need, therefore, to involve the devolved administrations in any of the discussion on rights protections. The risk of additional rights protections being seen as a power grab or a method of control from Westminster government must be acknowledged and mitigated. And one way of mitigating this risk could be to draw from the international and regional human rights instruments which the UK has ratified and which the government, from central to devolved level to local government level, are required to comply. The domestic provision protecting social rights could therefore simply be a way of incorporating into UK law legal obligations which the UK is already bound by internationally. In addition, and returning to my point on human rights protection systems, UK officials in both central and devolved government are used to reporting against these articles, so there would be a basis upon which to develop state capacity. In addition, civil society organisations across the UK, and if I may say national human rights institutions, are very experienced in monitoring and reporting on compliance with international standards. That's the conclusion of mine, although if I've got 2 minutes under the Barnett formula for Northern Ireland, I would just like to point out the right to education, as I said, it is already protected in the Human Rights Act, so I think there is a need to consider why additional protections are required and what they would look like. I also note that in the wording on the right to an adequate standard of living, it states that it's dependent upon an individual being legitimately present in the UK. And that's very much at odds with the concept of universality of human rights, which I think we'd all ascribe to. I also would point to, in relation to the right to housing, it says in accordance with the relevant law relating to housing and homelessness. But the very idea of rights is that they are matters that shouldn't be subject to legislation in the normal way. So there's some concerns with me, although I'm happy with the housing wording. Sorry to end on a negative.
No, not at all. Thank you very much, Colin. In fact, given that Professor O'Regan could not join us today, I'm going to use, rather than abuse my position as chair, to frame some of the discussion. I had a few comments before opening it up to the floor. We have plenty of time. I don't think anybody will be shortchanged. So just on Jeff's presentation, I was thinking, in some ways, UK is really better placed than many other jurisdictions in thinking about enforcing social rights, because it has thought more about political enforcement of laws and rights compared to legal enforcement, compared to any other jurisdiction. So there are umpteen jurisdictions, India, South Africa, etc., which have tried to think about how do we get politicians to do this stuff. Right? And the UK has been thinking about this for at least 30 years. So just want to add a few more things to the mix that Jeff very helpfully put on the table. The judicial due regard to social rights, Jeff, I'm not sure how much that will be helpful in practice. I'm thinking about Section 12 of the Human Rights Act that asks judges to give particular regard to the right to freedom of expression. And it does not seem to have played much role in practice in the court's adjudication. But there is a different due regard duty that has actually done a huge amount of work in litigation. It was put in as decoration in the Equality Act, Section 149. Those who are equality lawyers know. This is not judicial due regard, but a duty on public authorities to give due regard to the need to reduce discrimination, right? And that, I think, was put in as a feel good, it will never really do anything in practice, but it sounds nice provision. And a lot of human rights adjudication has actually been on, did this council, did that authority actually think about discrimination in this case? And I think that kind of proceduralized enforcement judges are very comfortable with because they're not being called upon to make substantive judgments here. Right? They're just asking, have you as a political authority given this thing sufficient thought? And I think there's some scope to think about that model, at least as a third limb of your two-pronged test, Jeff, which I thought was interesting. Um, and I'm also reminded, by the way, of the section 1 of the Equality Act, which is a due regard duty in relation to socio-economic inequalities that Scotland and then Wales more recently have brought into force. England, after 14 years of the Equality Act, has still not brought it into force. But maybe one of the first things, a low-hanging fruit for a new Labour administration, would be to bring Section 1 of the Human Rights of the Equality Act into force. The second model, and this is also, by the way, obviously connected to Stephen's point about the South African model, asking judges to spur political action, which is a territory where you will need to think about omissions. So a lot of what you said, Jeff, was about judicial power as a shield to protect against abuse, right? But especially in this context of social rights, when politicians are just doing nothing and that leads to a breach, I think something has to be thought about. And I don't think the right solution will be for judges to fix the problem themselves, but they have to have the power to force politicians to take a call, whatever that might be. But you can't just sit on it. You have to, do something about this issue. So those were the two things I thought in a procedural manner courts have a role. And then on sort of, guarantor or fourth branch institutions, I think I had a lot of sympathy for your monitoring role by just combining some of the things that Colin said and yours. First, I think multiple commissions here is probably a bad idea. Empowering the Equality and Human Rights Commission with new and real powers, both at the devolved and the Westminster level,
They can be redundant.
can be important. No. I mean, not in a single, not combining them, but not creating a special commission on social rights as distinct from the Commission on Civil and Political Rights. But also adding high political salience to the reporting and monitoring duties, right? So I really liked your human rights indicators idea, right? But we already have mechanisms like Section 19 of the Human Rights Act, where the minister has to tell Parliament whether this bill is in compliance with human rights or not. We know about the Office of Budget Responsibility. Can the law dedicate a one-day plenary parliamentary discussion on the report? Can the Commission put in human rights indicators that the Joint Committee on Human Rights and then the plenary session are forced to discuss? So again, not dictating outcomes, but proceduralizing and mainstreaming human rights thinking. So something, sort of Section 19 human rights, HRA plus duty, very much in the political constitutionalism traditions of this country. Stephen, on the second chamber veto, I think if it's going to be elected, it has to have a veto on everything. And, this is something that, I've told Jim before in the Brown 1 workshop. You can't have an elected chamber and then say no veto on legislation, but that's a different issue. I'm on the fourth point. The fourth point, again, on this, I was just thinking that, this is going to be politically popular. Social rights sell politically. I mean, housing, NHS, welfare, well, maybe not welfare. But is this an opportunity for Labour to shore up the legitimacy of the Human Rights Act instead of creating a separate legislative vehicle, a second schedule to the Human Rights Act, seeing the civil and political rights and social rights as one package, different enforcement mechanisms perhaps, right, tweaked in between, but they rise and fall together. So a greater measure of political entrenchment also for the civil and political rights, and getting rid of this stupid debate that keeps coming back about, repealing the Human Rights Act, etc. Maybe this might be a political opportunity to tie human rights with the NHS so that they sink and swim together. And finally, on political enforcement, just thinking back on Colin's point, instead of supermajority, which I worry British judges will be extremely cautious about enforcing, perhaps sort of giving more legal teeth to the Sewell Convention. So you can't repeal it without devolved consent might have more legal cachet than supermajorities. It's already there in the Scotland Act in Section 20, even with the word normally. Maybe you can do something with it. Anyway, I'll shut up there and stop abusing my position as chair.